Hi everyone, welcome back to Let's Talk Legal with Karimi Chege. My name is Ashley Karimi Chege, an advocate of the High Court of Kenya and your go-to employment expert. This is Season 1, Episode 2 of Employment Law Unlocked, where we'll be talking about termination/retirement on medical grounds. This is a continuation from Episode 1 where we talked about sick leave. So if you've not watched Episode 1, I highly recommend that you pause this video right here and proceed to watch the episode on sick leave so you can understand how we reached here. So what are the objectives of today's episode? One is to expound on what happens once an employee exhausts their sick leave days. Two, what are the conditions that must be met by an employer who's seeking to terminate his or her employee on medical grounds? And third, what are the consequences in the event that the employer fails to abide by these conditions? So let's get straight into the episode. So what happens once you exhaust your sick leave days? Once you're given all your sick leave days by your employer and you've utilized all of them, and you're still not in a position to come back to work, your employer can start to contemplate retiring you or terminating you on medical grounds. But let me speak to the employer. This process has to be done with utmost sensitivity and due regard, noting that we are talking about illness. Also, a sick or injured employee is highly protected under law. Article 27(5) of the Constitution of Kenya 2010 and Section 5(3) of the Employment Act provides that no one or no employer should discriminate the employee or anyone on the grounds of disability, where illness features. Therefore, an injured or ill employee does not lose their right to equality of opportunity by the mere fact of being injured or ill. Now let us talk about the conditions that must be met by an employer when seeking to terminate or retire his employee on medical grounds. 1. The employer must ensure that he explores ways to reasonably accommodate a sick employee. This could be limiting the working hours of such an employee to ensure that they have more time to recuperate at home. The employer could also change the working environment of such an employee by doing physical modifications to the workplace, or they can even go to an extent of purchasing special equipment to ensure that the sick employee still stays productive at the workplace. The employer can also reassign the employee to a new job that will accommodate the limitations of the sick employee. All this is done with an aim to ensure that the employee who is sick feels supported to recover and resume their initial position. So what happens once you as an employer have accommodated your employee but there's no much improvement in their medical condition? The employer can proceed to instruct the employee to present himself or herself before 3 medical practitioners who will examine the employee and prepare independent medical assessment reports that will establish when exactly the employee is going to be in a capacity to resume work in the foreseeable future. The reason as to why I'm emphasizing or I advise for 3 medical reports is because of the probative nature. One medical report is prone to challenge on the grounds of bias, especially where the employer and the medical practitioner are known to each other. For 2 medical reports, they could each give contradictory information which the employer will not be able to use, and hence that's why 3 medical reports would be best. In the event that the medical reports comes out indicating that the employee should be given 3, 6, 9 months to fully recover and resume work, the employer should reasonably accommodate such an employee during that period. In the event that the report indicates that the employee can come back to work but needs to be reassigned lighter duties, then the employer should abide. However, in the event that the report comes out indicating that the employee should be retired on medical grounds, then the employer is now justified to commence the termination proceedings under Section 41 of the Employment Act. We had talked about the provisions of Section 41 of the Employment Act on Episode 1, but just in brief, this entails the employer issuing the employee with a notice to show cause letter, the employer should give the employee a chance to respond to the notice to show cause letter. Thereafter, the employer should call the employee to a disciplinary hearing. The employee should be notified of the disciplinary committee's verdict after the hearing and be given a right to appeal. In the event that the appeal's verdict is still to retire or terminate the employee on medical grounds, the employee should be issued with a termination letter that clearly indicates that the employee has been retired or terminated on medical grounds. Thereafter, the employer should compute the employee's terminal dues and issue the employee with a certificate of service. All this should be placed in context of how sick the employee is. Now let us talk about what happens if the employer does not abide by the conditions therein. The employer will be deemed to have unfairly terminated the sick employee, both substantively and procedurally. This will mean that the employer will be liable to pay damages for unfair termination, or the court may even order that the employer reinstate the sick employee back to work. Now let us talk about the case of Kenya Plantations and Agricultural Workers Union versus Ria Vipingo Plantations Limited and Dr. JJ Ashraf. So in this case, Joseph Ouma Olo was a member of the Kenya Plantations and Agricultural Workers Union and an employee of Ria Vipingo Plantations Limited. He was employed as a sisal cutter, and in 2014, he developed hernia, was unable to go to work, and had to take sick off so that he can be able to attend to his medical condition. He was hospitalized at Kilifi Hospital, where he was scheduled for reconstructive surgery to remove the hernia. The surgery was successful, and the doctors, through a report, recommended that upon resumption at work, he should be allocated lighter duties. However, the employer did not abide to the report of the doctor, and Joseph resumed his work as a sisal cutter as always. In December 2014, the hernia reoccurred, and Joseph was taken to Saida Farida Hospital, where he was scheduled for another reconstructive surgery to remove the hernia. In frustration, while he was awaiting the surgery, he wrote a letter to the employer, noting that he had already exhausted his sick leave days. He was no longer receiving a salary. He informed the employer that he was suffering, his family was suffering, he had not been allocated any lighter duties, he had not received his salary for so long, and it was better to retire than to continue working as a sisal cutter. 2 days after receiving that letter, the employer went to Dr. JJ Ashraf seeking a medical opinion on Joseph's condition. The employer informed Dr. JJ Ashraf that Joseph had already exhausted all his sick leave days and has been away from work for quite a while because of the illness. Dr. JJ the same day made a report indicating that Joseph should be retired on medical grounds after his surgery at Saida Farida Hospital. The surgery at Saida Farida Hospital was successful. The hernia was removed, and the doctors at Saida Farida Hospital recommended that Joseph be allocated lighter duties when he resumes work. However, when the surgery was done with and he was recuperating well, Joseph received a letter of retirement from his employer in March 2015, indicating that he had been retired on medical grounds on the strength of the report by Dr. JJ Ashraf. Shocked by this, Joseph sought an opinion from the Director of Occupational Safety and Health Services in the coastal region, that's the DOSH office, on his medical condition and whether he should be retired on such grounds. The DOSH office indicated that hernia is not a disease that warrants termination on medical condition. It is a congenital issue that can be corrected through reconstructive surgery, and recommended that the employer should reinstate and allocate him lighter duties to accommodate his current his current medical state. However, the employer did not abide to this, and the court was faced with the task of determining whether Joseph's retirement on medical grounds was done fairly and lawfully. The court took time to look at each and every medical report. The court noted that the report from Kilifi Hospital, Saida Farida Hospital, and the report by the Dosh Office Coastal Region all indicated that Joseph was still fit to do his work as long as he was allocated lighter duties. On the other hand, Dr. J.J. Ashraf's report seems to have been hastily done, noting that it was done within a day, did not make reference to the report from Kilifi Hospital as it should have, only regurgitated the information that the employer needed to terminate or to retire the Joseph on medical grounds, and made final orders in regards to the medical health of Joseph, yet he had not even undertaken his second operation at Saida Farida Hospital. Therefore, the court found that the employer relying on one medical report, the one of J.J. Ashraf, to make a verdict of retirement of Joseph's employment on medical grounds was unfair and unlawful. Therefore, in making its orders, the court stated that the employer should reinstate Joseph to employment and allocate him lighter duties for a period of 9 months, noting that the report at Saida Farida Hospital had indicated that it would take Joseph a period of 9 months to fully recover. Thereafter, the orders indicated that the employer should ensure Joseph is taken through periodic medical assessments to just keep tabs with his medical status. Upon the lapse of 9 months, the court ordered that the employer was justified to consider retirement on medical grounds or full reinstatement upon issuance of a final medical report on his health. So what can we learn from this case? 1, it is important that employers handle sick and injured employees with due care and sensitivity, noting that no employee would wish sickness upon themselves. 2, it is so important that an employer ensures that they explore ways to reasonably accommodate sick and injured employees in the workplace, failure to which the employer will be deemed to have unfairly terminated or retired an employee on medical grounds and will be forced to either pay damages for unfair termination or will have to face the wrath of reinstating such an employee back to work under favorable terms. That marks the end of episode 2, and stick around for episode 3, where we continue to talk about the benefits under the Employment Act. Thank you so much for watching, and see you on the next one. Remember, information is power, legal knowledge is freedom.